everyone. So James Smith here. I am a partner here at MHA and lead our global mobility business. So essentially, any employee who crosses an international border in their relationship with their employer. After my section, I'm going to connect with Jonathan Dowding, who's one of our directors here, who's going to continue on a bit more of the corporate tax front here. What I planned on talking about today was international business travelers and some of the risks that arise with those, and also some of the potential mitigations that we have. Just as a starting point, what I wanted to just pick out on this slide was just a few points about business travelers and some of the wider implications that come with them when they cross an international border. So just for context here, when we're talking about business travelers, I'm not talking about permanent relocations or international remote working or international assignments. This is employees who cross a border for a short period of time. And on the screen here, I've just got a few of the considerations that need to be looked at with this, because I think often it's thought of, oh, we have a tax impact, don't worry, there's a treaty or something that says no tax is due. But we've got a lot of other wider considerations that need to be thought of. So I'm going to delve a little bit into the income tax treaty point in just a couple of minutes, but just a few of these other points on the screen now to start with. Immigration as a first point. So often when you have an individual who crosses a border, so they go out of the UK or possibly into the UK, we rely on some form of visa waiver. So for example, an ESTA going into the US or other electronic visa system. Those are often okay, but it does depend on the nature of the duties. So a fundamental point here is understanding what somebody is actually doing. So if someone's going to, say, meet a client or do annual reviews, meet their team, those visa waivers are often okay. But if they're actually delivering services in that location, then that position might change and there might be some form of immigration consideration that's needed. So that's probably my first point is, do you have the right immigration clearance for somebody working in that country? We then look at Social Security, and Social Security is actually going to be my next topic on the next FD update. But we need to make sure that Social Security coordination between locations is met as well. So the UK and many countries have what we call a reciprocal agreement, and that essentially says that subject to certain conditions, Social Security remains in the home country only. That sometimes does actually require some form of proactive application to, say, HMRC to confirm that position. So if you have somebody, say, going from the UK into the EU, we need what's called an A1 for business travellers. And an A1 essentially confirms HMRC's view that that individual stays subject to UK national insurance and not some form of local social security. So again, it goes back to that point of understanding where people are and making sure that you've got the right processes in place. Another point here, which is quite important, especially for organisations sending people into the European Union, is Posted Workers Directive. This is a few decades old now, but is really just coming into play now. And essentially, Posted Workers Directive says that if you're sending somebody into a location, that you need to make sure that minimum host country labour standards are met. So things like termination, minimum pays, are your people going into that location meeting those minimum standards? But the fundamental point with Posted Workers Directive is that it's not automatic. There is a requirement to notify host authorities. Now, as always with the European Union, there's different implementations and different countries have different interpretations. But the fundamental thing is here that many EU countries say that you have to pre-notify in advance of travel that individuals are coming into your location. So that might be some countries just a day, other countries might be another set de minimis period. But again, the fundamental point is to understand where people are, what they're doing, and do you have any of these other requirements? And then just big picture as well, when you're sending people around the world for business travel, we've got these other considerations, which I'm not going to delve into too much here. But for example, are you meeting GDPR? Do you have any additional duty of care or employment rights that you've got to start to think about? But the main point that I really wanted to go into today was regarding the double tax treaty. And I've got a consolidated view of the articles that we look at as part of a double tax treaty. And essentially what we're doing here is we're trying to say, can income tax in the host location be removed for business travelers going into that location? So, for example, as a simple way, you have somebody leaving the UK to go into France for a series of business trips. We want to rely on the UK-France double tax treaty to say that there's no French income tax going to be due. One of the biggest things that I see when I speak to my clients, and I'm sure people have heard it before, is it's less than 183 days, so I'm all okay. And that's one of the conditions that we need to think about, but there's a whole raft of other considerations when it comes to double tax treaties and income tax. For anyone on the call who's read a double tax treaty, they're quite difficult to understand, actually, the nuance in language. But just as a big picture, a double tax treaty is typically about 30 pages long. So they're not the longest things in the world. But fundamentally, if you look at the OECD guidance note or the commentary on a double tax treaty, it's about 2,500 pages long. So just reading the language exactly how it's written in a treaty is possibly not going to be giving the answer that actually the treaty is meaning. So if I just run through how we approach a double tax treaty for business travelers, and then we can start to see actually, is there some form of reporting or other tax exposure? So the first thing that we need to do when you have a business traveler coming into the UK or leaving the UK is firstly understand, is there a double tax treaty to start? In the absence of a double tax treaty, you can see my big purple or pink line here, taxes potentially due in the host. So if there's no treaty, automatically we've got no mechanism internationally to remove tax. And then we've got a number of conditions, and if we just work our way along the top line to the right, under 183 days of presence. This is one of the three main conditions, and it's what people latch on to quite often. But that 183 days is counted in different ways. A day is typically a day of presence. So if you fly in and fly out on the same day, that's a day. But over how many, or what period is that 183 days counted? So it's typically a tax year, a calendar year, or a rolling 12-month period. And so again, understanding the treaty and what that means for day counting is really, really important. So let's assume we've got a double tax treaty. We're under 183 days. We then need to make sure, is the individual creating a permanent establishment or essentially a corporate presence on behalf of their home employer in that location? Jonathan's going to talk about permanent establishments in a minute, so I'm not going to dwell on that one. So under 183 days, no permanent establishment. And this is where we get into the bit more nuance of language, and we start looking at who is their employer, and essentially that is legal and economic. From a UK perspective, if we have a UK company with a foreign branch, from a UK tax law, that is legally indistinguishable from the UK company. So if we have an individual as an employee of a foreign branch of a UK company, and that individual comes to the UK as a business traveler, we immediately have tax obligations in the UK from day one. So anyone who has a foreign branch with people coming in, that really does need to be looked at because the treaty is not going to cover that. What we also look at when we look at double tax treaties is where costs sit, but also who what we call the economic employer is. And this is a real fundamental point here, because whilst a legal employer might be outside the UK or outside the host country, if the economic employer is within that location, then again, we might have tax due in the host. Economic employer, I'll just run through quickly on this next slide, but it essentially looks at substance over form. So in practice, is the individual performing services that are integral to that employer. So even though their legal employer is someone else, if they are integral to the host country, if the host country is bearing the economic reward and suffering any risk if it does arise, those are indicators that they are the economic employer. If the host country is directing the work, how it's undertaken, and they're paying the costs, so for example, cost recharges, again, it's likely that they're the economic employer. And so if I go back to this slide again, we start to get this picture that there's a lot of points that need to be considered when we're looking for tax to be due or not. And I'm going to just go very quickly in the last couple of points, but essentially, if we get to a place where this tax relief is going to be available, we go down here, there still may be some form of company reporting. So in the UK, for example, there's a requirement that all inbound business travelers are reported to HMRC on an annual basis. And that's called Appendix 4, or short-term business traveler reporting. So there's a requirement that companies track and monitor who is coming into the UK, and then undertake annual reporting to confirm to HMRC that we have these business travelers coming in, we've reviewed the relevant treaties, and all of those treaty conditions are met. If we're not in that place and tax is potentially due in the host, either the UK or another country, I think it goes without saying there's going to be some form of company reporting. So my big picture on double tax treaties and wider business travelers is all businesses that have some form of business travel internationally are really expected to understand where their global business travelers are. So that requires mechanisms to track and monitor who they are, what they're doing, and then fundamentally understand if there's any obligations, tax, or if there's no tax, to do some form of company reporting. Just finally, on that company reporting point, the UK is not alone in having some form of business traveller reporting requirement. Ireland has something similar, Canada has something similar, other jurisdictions as well. So it's really about making sure that understand where people are, what they're doing, and then confirming that some form of tax relief is available or what reporting is going to be needed. So with that, I'm going to hand across to Jonathan, who's going to delve a little bit more into that permanent establishment point that I just spoken about.
Thank you very much, James. Yeah, and that's some really useful stuff on that. And there is a lot of overlap, hence why we've got the kind of sessions one after each other. Okay, so let's move on. So. Right, if we start then, so what is a permanent establishment? I'm sure many of you have kind of dealt with this, whether directly or indirectly, and have at least considered the risks. Perhaps you've had an exercise done over the last few years. Maybe that's ready for a sort of a dust off as we go through. We'll see there's a bit more guidance on one of the points, and it's always worth considering whether the double tax treaties have changed as well. As James says, very complex to work through those often. So what is a PE? The long and short of it really is where you have a company or an entity in one jurisdiction that's carrying on enough activities to create that permanent establishment or taxable presence based on the number, the extent of the activities that it's actually carrying on in that other jurisdictions. So it's a taxable branch or a taxable PE, as we'll call it. One example we've kind of put in here, this could be a US LLC. With it may have a full UK office, multiple UK employees carrying on part of its trade or independent trade from the UK, and therefore quite a clear, obvious example. Conversely, it could be a UK company carrying on activities in the US or France, Germany, any number of countries, and clearly one company in one country could have multiple permanent establishments in multiple countries. So really is a real global issue, and can get quite complex quite quickly depending on what's being done. So what is the existence of PE? What are the implications for the business where it's got a PE in X number of jurisdictions? Well, in addition to the kind of local registration and filing requirements, ultimately you're looking at a potential local tax liability. In some cases, if this is just a single person that's created this taxable permanent establishment, the actual tax liability may be fairly limited. They may be carrying on a limited sort of function, and Yasmin's going to talk about transfer pricing a bit later on. But yeah, what's the attributable profit to that UK to the UK activity? So that could be a fairly small number. I guess the risk really is if you've had a permanent establishment for a number of years and haven't registered, haven't carried out the the administration there, haven't filed the returns, the sort of the interest penalties and tax and the reputational risk of getting this wrong. We've got naming and shaming in the UK, other territories do as well. So it's really that side of things more than we've got a massive tax bill. It's kind of all the bits and pieces that come with it. So it's one of the reasons why it's important to get this right and address it early on. It's kind of a common theme throughout, really document everything and make sure that decisions and guidance is all clear internally. So there's two main forms of PE or ways of creating a permanent establishment. This is reference to the OECD Model Tax Convention or the Model Tax Treaty. This is implemented in the UK with our domestic rules, which are very similar to the latest Model Tax Treaty, and will very shortly, with effect from 1st Jan 26, be fully aligned with the model tax treaty. So this is why I'm going to be referencing the model tax treaty really. And broadly, I mean, James made the point that everyone follows these kind of model articles, but really has a different interpretation. Even within kind of supranational groups like the European Union, there's still going to be difference in interpretation and the actual implementation of these kind of rules. So yeah, good to have the model treaty, but you need to look at domestic law, you need to look at case law, you need to look at interpretation, everything. So it does become a bit more complex. So if we take the UK as an example, in addition, and this is common throughout the world really, you can create a taxable presence by dealing with land where you might otherwise fall outside the PE definition. Dealing with real estate and immovable property tends to bring you into the charge to tax as well. But that aside, if we're just talking about services and traditional sort of trades, non-land related trades, you can have a fixed place of business PE. That could be an office or a construction site, an installation, something kind of fixed and permanent. Or it could be you could create a PE by through the dependent agent PE. So that's having someone on the ground that's essentially got the authority and is actually negotiating contracts and meeting customers and concluding contracts really with on behalf of that overseas territory, which can create that taxable presence. So James has touched on the double tax treaties, how that can provide relief. With respect to permanent establishment risk, that can actually raise the bar, depending. I mean, yeah, obviously, assuming there is a double tax treaty between the two jurisdictions, it can raise that bar. So maybe instead of sort of substantially negotiating a contract, it might more or less say you actually need to be signing the contract in the overseas territory to create a dependent agent PE or similar. But we'll sort of come on to sort of double tax treaties very high level really, and how that can be a bit more complex. So moving on. So this is really coming back to that fixed place of business PE. We had some guidance released as the back end of last year, so November 25, and what that's done is it's essentially clarified when a home office. Obviously, sort of the proliferation of the use of the home office through COVID and for the years after. Originally, sort of 2022, 2023 onwards, there was a relaxation on when, on the use of a home office. There was an appreciation from most sort of local tax authorities that it's everyone's kind of stuck at home, not much you can do there. That didn't necessarily create a PE in and of itself. I think this guidance moves away from that. It's probably more in line with the various other sort of initiatives and rules. Everyone wants a slice of the pie. So this does sort of it clarifies the position, and maybe this in and of itself is a reason to dust off that permanent establishment risk assessments that you may have done, and really look at what your employees are doing globally. Are there any risks there? Does that need to be looked at again? Do we need to manage those risks? That's certainly a lot easier than trying to look back on a historic issue 2, 3, 4 years old where you've got to fix the position. That's obviously going to be a lot more complex, time consuming and ultimately expensive. So what the new tests do then, just looking at home office remote worker PE risk, these new tests, we've got the 50% of working time test and it's important to note it's an and test and the commercial reason test. So really, I mean, the way to approach this is probably looking at the commercial reason first. So if you've employed someone in an overseas territory, you've got to ask that question and document the reasons for hiring that person in that country. Are they there because you needed someone in France who had to go meet French customers on a regular basis? And that's why you've put the job ad out for someone in France in this example, or were you looking for a programmer that's going to be, it doesn't really matter where they're based, you're kind of location agnostic, you put the offer out and they just happen to live in I don't know, Poland or somewhere like that. So if you don't meet that test, then we don't really need to look at the working time test. But this is another point just to kind of looking at one of the examples in the guidance. So if an employee is working from home over 50% of their time, 50% or more, so say 80%, I think is one of the main examples, and they were there specifically to meet local customers, then that's going to increase your PE risk considerably. That's not to say that if they spend in less than 50% of their working time working from home or a non-company location in the overseas territory, that it reduces your risk entirely, but it does indicate a lower risk. So all of these factors to bring in, maybe not a complete change in the landscape, but this additional guidance does, it gets you to maybe a more comfortable filing position. So always, the more guidance is better on that front. So this applies to the existing double tax treaty provisions. So it's essentially already in from 1st of Jan, and is being adopted in domestic rules. As I say, in the UK, we're aligning fully with the OECD model treaty, and other countries have already brought it in. We're already seeing that in the kind of the risk assessments, just additional steps, additional questions when you're assessing risk, but can provide more certainty. So not all bad on that front. As I say, the update really reinforces that need to document everything, document decisions, provide guidance to staff that are working remotely, in addition to all of the points James made. This is just that additional tax risk. So, and the question always asked, well, how do the local tax authorities know that you've got people on the ground doing things there? Well, or normally you're VAT registered in those territories, or they may be on local payroll, etc. So there's many ways that can trigger the question. And we are seeing more of a focus on that, on the PE risk. So something really to keep an eye on and watch out for. Just going to spend a minute or two, kind of very similar topic or an overlapping topic with that, and the whole theme of overseas workers and the remote workforce. Is more focused probably on the more senior stakeholders that are working overseas. So just briefly, in taking the UK scenario, we've got 2 ways that you can be tax resident in the UK. There's the incorporation test. Is the company incorporated in the UK? That's your default position. It'll be UK tax resident. Then you've got the central management and control test. Now, most countries do have both of these tests or similar tests, notable exception being the US. They just have the incorporation test. The risk here, though, is that you're incorporated in one territory and you're centrally managed and controlled in another territory, or that second point could be ambiguous. And there you've got a dual tax residency risk. Now, we do have double tax treaties with many countries. The UK does. And there will be a tiebreaker test in most of those countries. One of the outcomes of the recent kind of BEPS 1 initiatives, though, is this multilateral instrument. So it's essentially a way for countries to vary these double tax treaties without going through the full negotiation process. And that has been kicking in over the last few years and is in place for many jurisdictions. What that does with respect to dual tax residency is it brings in, it makes the tiebreaker test a bit harder. You have to, in many cases, get permission from both jurisdictions. So go for the mutual agreement process, the MAP process, which can be time consuming and costly and might not lead to a clear answer. So that can take many years. So always the advice really is to mitigate that risk and manage those risks and really think about the structuring and whether it's suitable to have an entity in location X or Y. So this is a change that needs to be factored in. It's no longer a case of self-assessment. Well, we're making all the decisions, all the board meetings are happening in Luxembourg or Ireland or wherever, so we're okay. You have to look at it in a bit more detail and just be a bit more conscious about those kind of decisions. So yeah, again, really important for managing these tax risks and ensuring that you're not left in a position where you're being taxed in 2 territories with no relief because you haven't got the resources to go through the MAP process. Document everything, make sure those decisions are on file, and maybe don't rely on sort of assessments that are several years old as the landscape does change and interpretation changes. Okay, so that's a real whistle-stop tour on PE and tax residency risks. I'm going to hand over to Yasmin for transfer pricing.
Thanks, Jonathan. I think it really highlights having a mobile workforce is really important from a retention of talent perspective, but there's so many headaches and bear traps that you can fall into, etc. So look out for that, and don't hesitate to reach out to James and Jonathan with any complex questions.